We'll go into that. Come forward. 25 CR 307 is called the State of Texas versus Mitchell Joseph Sylvester. Is that you?
Yes, sir.
All right. You were here. This is an initial appearance, and Ms. Minaldi has been appointed to represent you. My God. You were charged here with the first-degree felony of aggravated robbery, which carries with it up to life imprisonment if convicted. But it doesn't end there. I'm looking at 4 prior felony convictions beginning in 1980, aggravated robbery. And you were convicted in the court next door, and that's 45 years ago. And then 8 years after that was final, you apparently committed illegal possession of a controlled substance, a second-degree felony, and were convicted of that in 1988 in this court. Thereafter, that became final. You committed the felony of another illegal possession of a controlled substance and was committed in 1991. You were convicted next door in the 252nd. After that became final, you committed the felony of having a prohibited substance in a correct.
Let's break down what just happened here. Judge Boyd just laid out a chronology of felonies that would make even career criminals flinch for separate serious convictions, including aggravated robbery, drug felonies, and bringing a banned substance into prison. Now here's why that matters. Under Texas law, repeat felons, especially violent ones, face enhanced sentencing, meaning Sylvester could be looking at 25 years to life without parole if convicted again. And because a deadly weapon was allegedly involved, parole eligibility would require serving at least half the sentence. That's a minimum of 12.5 years. Even on the lower end. This isn't just an arrest. This is potentially a final chapter.
Facility, a third-degree felony, and you were finally convicted of that in 1996 in the 252nd District Court. So, if all of this, if you were found guilty and all of this were proven true, you are looking at no less than 25 years in prison, up to life in prison. And since a deadly weapon was used, of course, you would not be parolable for whatever sentence up to life until you served at least 50% or half. Do you understand how serious this is? Do you understand how serious this is, sir? You went through the system 4 separate times in felonies, and you were back with a violent crime? That's a rhetorical question. I don't expect an answer. All right. What do you want to do today, Minaldi, as his lawyer? Does he have an indigent form? I guess he's indigent. I don't know. But does he have an indigent form?
We are going to work on it after I'm done with my appearance because he doesn't have his glasses. So I'm going to hold him.
There was something done here where 4 things were filled out. Just 4 spaces out of this multi-page document, and then it was approved by a magistrate. You just can't make this stuff up.
Hold up. Did you catch that? The court-appointed financial affidavit, the form that determines if someone gets a free lawyer, was only partially filled out and somehow still got approved? Judge Boyd doesn't even hide his frustration here. It's a rare peek into how bureaucratic shortcuts can slip through even the most critical moments of justice if the basics aren't done right. What else might fall through the cracks? Let us know in the comments. Should a case this serious ever have paperwork half done, or is that part of a bigger problem in how overloaded courts operate?
It needs to be fully filled out.
I'm going to work with him.
It was half done.
Yes, sure.
I'm sorry. It was 1/10 of 1% done.
Your Honor, I believe
What is his bond?
25,000 is
How
way
did that
too low.
happen?
I'm not sure, Your Honor, on that. That's,
Who set the bond on that? Because that's just,
I believe that was Mr.
no, it's like one of the Jacobs. And that's, problem. Well, I don't know, maybe.
I don't know if it wasn't, maybe they let him out on that accusation on it. He said it at the 25,000. But it's alleged that he took a machete and was robbing a game room here. And the lady that he was robbing, she tripped and fell as she ran out the door, and he grabbed her by the ankle and tried to drag her back into the game room there, at which time she pleaded that for her life because she had kids, and he did let go of her ankle and attempted to run back into business with a machete. And one of his prior convictions is actually an act.
This is where the story takes a chilling turn, according to the allegations. Sylvester entered a game room with a machete, robbed a woman, and in a horrifying detail, allegedly grabbed her by the ankle as she fled, trying to drag her back. Inside, she pleaded for her life, telling him she had children. That's when he let go. Now, we can't say what's true until trial, but this scene alone paints a terrifying picture. The emotional trauma that comes from a moment like that, unimaginable, and yet a $25,000 bond. Where with Judge Boyd on this one, it doesn't add up.
Aggravated robbery as well, in addition to him being habitual.
Court has reviewed the probable cause affidavit and the defendant's prolific criminal history, which is in the public safety report, which convictions, and we know that at least 4 of those are serious felony offenses, including violence.
Let's talk bond. Initially set at just $25,000, the judge calls that woefully too low. Why? Because bond isn't just about whether someone can pay, it's about risk to the public. And flight risk, with 12 prior convictions, including aggravated robbery and alleged use of a machete, Sylvester presents both. That's why Judge Boyd raises it to $100,000 and orders a GPS ankle monitor. And here's the clever part. He limits Sylvester to home confinement, allowing only job searches and food runs. That's not just punishment, that's precision. Legal control. Do you think that was the right move? Drop your thoughts below.
Crime of aggravated robbery, which is what the defendant is now charged with once again. And $25,000 is woefully too low. So the defendant's bond is $100,000. You must have a GPS device if you post your bond so that we know where you are at all times. When a robbery occurs in this town, we want to make sure it's not you. And you would be placed on home confinement, except for purposes of trying to find a job and going to and from to get food in the direct routes possible. Do you understand the seriousness of what you're charged with, sir? Your criminal history and the fact that this was committed in a very violent fashion, where a machete was alleged to have been displayed by you in the commission of this crime, and threatening the victim. Are you working somewhere right now? How did you post $25,000 bond? Your niece. Who's your niece?
This moment stings. The judge asks how Sylvester managed to post the original $25,000 bond. The answer: his niece. That detail lands like a gut punch because behind every defendant is a family who's impacted. But the judge doesn't hold back. He reminds Sylvester and all of us that freedom is fragile. One choice, one moment of violence, and you lose it all. You can feel the weight here. This isn't just a legal issue, it's a life issue. He's been through the system so many times, yet here we are again. Would you have helped post his bond if you were in his niece's shoes?
Sure. And yeah, my brother's dog.
Your brother's son. I just, you know, you have been through this system so many times with crimes. You've got 4 serious felony offenses here that have been alleged. You know that actions, criminal actions, have consequences that can hurt victims, but hurt you as well. You lose your freedom. You don't want to lose that, but we have to live in peace.
I need help. Contact.
No, talk to this is the lady who's been appointed to represent you. Talk to her first before you say something, because everything you say is, some people want to say something, and when they say something, it can hurt them at trial. They go, well, I did it, but I was really kidding around or something like that. It works against them. So you don't want to speak until you talk to her first. If it's something you need to talk to me, that's fine.
Now here's something you rarely see in real time. A judge offering real-world advice that could make or break someone's trial. Judge Boyd warns Sylvester not to speak, not because he's silencing him, but because every word could be used against him. We've all seen it in viral cases. Someone blurts out a half confession thinking it'll help, but it hurts them at trial. This is exactly why defense attorneys stress, say nothing until I advise you, the judge is giving Sylvester a lifeline, even after all his prior convictions. Smart move or wasted effort? Let's hear it in the comments.
But the court agrees with the state that the bond is woefully low, too low under the circumstances and your incredibly rich criminal history of violence. Okay. I want to like an announcement in 4 weeks.
Yes, Judge, if we could keep him on the same docket for similar week as Crystal Row that we reset 5 weeks.
Okay, 5 weeks. Okay, good. Thank you. Yes, ma'am.
Thank you.
We'll do that. That is all. You were in custody, sir.
So here's where we land. Mitchell Sylvester, a man with 12 convictions and a decades-long criminal history, now faces a potential life sentence after an alleged violent robbery involving a machete. Judge Boyd didn't hold back, raising the bond, enforcing monitoring, and laying down the emotional weight of Sylvester's choices. This wasn't just a routine hearing. It was a clear warning. Repeat violent behavior will be met with escalating consequences, and the courtroom has no patience left for excuses. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. You won't want to miss what Judge Boyd does next.